The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is Diamond Candles, LLC versus Winter et al., and we will hear from the appellant.
Good morning, and may it please the court. My name is Allison Becker. I'm with the law firm of Gordon and Reese, and I represent the appellants in this case, Symphony Commerce and Henry Kim. As you, I'm sure, are well aware, this appeal centers around whether the Symphony defendants should be subject to a lawsuit in North Carolina, either based on sufficient minimum contacts to establish personal jurisdiction or based on application of a forum selection clause in the contract between the parties. I am mindful this morning that we are here on an abuse of discretion standard, and specifically, we believe that the abuse of discretion in this case lies in the disparate way that the business court treated the Symphony defendants versus the other defendants who were dismissed from the North Carolina action, namely defendant Baker-Botts and defendant Lee. So turning first to the question of personal jurisdiction over the Symphony defendants, plaintiffs have conceded that they are not trying to argue that their general jurisdiction lies over these defendants. So we're talking about specific jurisdiction and whether these defendants had sufficient minimum contacts with the forum state of North Carolina such that due process would allow North Carolina courts to exert jurisdiction over them. The business court decided, based on a showing of extremely similar facts and circumstances, that the Baker-Botts defendants did not have sufficient contacts with North Carolina to establish that jurisdiction, but somehow the Symphony defendants did. So the Symphony defendants, in support of their motion to dismiss based on lack of personal jurisdiction, submitted affidavits to the court from Scott Armstrong and from defendant Henry Kim. And these affidavits collectively established that Symphony does not have an address in North Carolina, does not have a phone number, has no servers, employees, property, offices, inventory, none of that in North Carolina. They had no other clients in North Carolina. There was a contract between Symphony and Diamond Candles, a North Carolina company, but all services under that contract were provided by Symphony in California. Symphony signed the contract in California. Mr. Kim is a resident of California. And while Kim did make several trips to North Carolina, the plaintiff and the court, the business court in this case, focused really only on one trip in its decision that they had made sufficient minimum contacts with North Carolina, and that was a trip in November of 2012. Meanwhile, Baker-Botts defendants submitted affidavits that Lee was not licensed in North Carolina, that all services were provided in California, that 1.1% of Baker-Botts clients were in North Carolina, and less than 0.8% of its revenue came from North Carolina. Now, with a firm like Baker-Botts, which certainly has more than 100 clients, 1.1% of clients could easily be more than the one client that Symphony had in North Carolina, Diamond Candles. Same thing with that revenue. Just because they expressed it in terms of a percentage doesn't mean it's not a substantial amount of revenue coming from multiple clients in North Carolina. The complaint also alleged that Lee and Baker-Botts participated in soliciting the relationship with Diamond Candles. And the business court in its order made some detailed findings of fact regarding the Baker-Botts and Lee contacts with North Carolina. In the preliminary sections of its order, it mentioned the 1.1% of clients in North Carolina, less than 0.8% of revenue, the lack of an office, the lack of a North Carolina license. But the business court made no similar findings of fact regarding the assertions in the Kim or Armstrong affidavits. And actually, at one point in its order, the business court curiously noted that Kim had put forth no evidence regarding his contacts with North Carolina, which is just incorrect. So despite the court, went on to cite a case called Diamond Healthcare in its order, and explaining that in cases where performance under a contract is intended to be performed outside the forum in question, courts are reluctant to assert personal jurisdiction over non-resident defendants. And the business court also noted that there's a clear difference between aiming services at a North Carolina resident and contacts within the forum itself. Going on to cite the Roy Corp case in paragraph 52 of its order, saying that, quote, it is necessary to distinguish between a defendant's acts which are aimed at a plaintiff who is located in a forum and those which are aimed at the forum itself. Only those acts in the second category constitute purposeful and deliberate contact with the forum, which makes it fair and reasonable for the forum to exercise personal jurisdiction. And so the business court went on to apply that analysis to the Baker Botts defendants and find that despite having multiple clients in North Carolina and a portion of its revenue coming from North Carolina, and despite being involved in the solicitation of business from Diamond Candles, that analysis meant that Baker Botts and Lee were directing their services at a North Carolina resident and didn't really have contacts within the forum itself. And correctly, in our mind, dismissed the Baker Botts defendants from the case for lack of personal jurisdiction. Curiously, the business court then went on to ignore the evidence put forth by the Symphony defendants, finding instead that Symphony and Kim had sufficient minimum contacts and stating that, quote, the path to jurisdiction is clear over them. But the business court didn't really explain why and didn't make sufficient factual findings why. The business court seemed to focus on two primary actions by the Symphony defendants that, in its mind, provided sufficient minimum contacts here. The first is the amount of money that Symphony made pursuant to the services agreement. And yes, it's $22 million as alleged in the complaint. That's a significant amount of money. However, we don't know what percentage of Symphony's business that was. And like I pointed out before, simply because Baker Botts listed their revenue as a percentage of business instead of a quantifiable amount, I'm sure that is one of the largest law firms in the country. 0.8% of its revenue could easily be in the multiple millions of dollars. So one contract, albeit a valuable contract in a state, is just not sufficient to be considered purposefully availing itself of the privileges and benefits of North Carolina law. The second factor that the business court appeared to focus on was the fact that Symphony offered stock options to Justin Winter, and the court curiously read that as a reason that Symphony was somehow marketing itself or availing itself of the North Carolina law and the North Carolina forum. Instead, that fact actually cuts the other way. The stock options were offered to an individual in North Carolina for ownership of a California company governed by California law, located in California, and providing services in California. Now, I could not find a North Carolina case directly on point analyzing the issue of whether a grant of stock options to a North Carolina resident somehow means that the company granting those stock options is now subject to North Carolina jurisdiction. However, cases in other jurisdictions have held that the stock options actually subject the shareholder to jurisdiction in the forum state of the business and not the other way around. And some cases I can provide as examples are Fields versus INA Filtration Corp. And that was in the Supreme Court of South Carolina in 1987 292 SC 614. And the McDermott Inc. versus Canciani case, that was a Second Circuit case applying Connecticut law. It's 525 Federal Appendix 8, 2013. And in that case, the court said, quote, the employee purposefully availed himself of the laws and privileges of the state by choosing to invest in a Connecticut employer. And so I would argue that's exactly what happened here. The Justin Winter, as a North Carolina individual, choosing to invest in a California company should have no bearing over whether that California company has sufficient minimum contacts with the state of North Carolina such that it should be subject to personal jurisdiction in the state. So we would argue, therefore, that it was an abuse of discretion for the court to conclude, based on the facts and circumstances in the defendant's affidavits, that the Baker Botts defendants did not have sufficient minimum contacts with the state in this case, but the Symphony defendants did. Focused only on the fact of a single contract in North Carolina and stock options that happened to be granted to a North Carolina individual. If the Baker Botts activities as alleged in this matter were insufficient to confer jurisdiction over those defendants, it's just logically inconsistent for the court to have ignored the similar facts and circumstances surrounding Symphony and Kim's activities with regard to these transactions and have treated them differently in this case. And finally, I know there have been some questions in the lower court about the other acts surrounding the making of the contract. And that, you know, there were communications between Kim and Winter about Plan B. But I would argue that those communications are also not enough to establish personal jurisdiction. In one of the cases actually cited by the plaintiff in their briefing, the Weissman versus Blue Mountain Organics case, which was another business court case decided by Judge Gale, the same judge in our underlying decision. Judge Gale said, the North Carolina Supreme Court has never adopted a conspiracy theory of personal jurisdiction, and this court declines any invitation to adopt that theory that appellate courts have not yet embraced, particularly because that invitation rests only on conclusory allegations with scant, if any, supporting evidence. And so I would argue that here, the conspiracy theory of personal jurisdiction should also not apply. We're talking about an individual relationship, and there's simply been no showing that Symphony defendants had continuous, ongoing marketing or business presence within the state of North Carolina such that it could reasonably be anticipated it would be hailed into court here. And so moving on to the question of the forum selection clause, if the court is not convinced that it was an abuse of discretion to deny Symphony and Kim's motions to dismiss based on personal jurisdiction without any true findings of fact to support that denial, in the alternative, we argue that the business court should have enforced the forum selection clause in the services agreement and required that the case be litigated in California. And while plaintiff's case is not styled as a breach of contract action, the main thrust of the entire complaint centers on whether the defendants somehow inappropriately drained value from the company in order to attempt to acquire it at a low price and essentially flip the company. The plaintiff has conceded that the mechanism by which the defendants allegedly drained value from the company was through the services contract with Symphony Commerce. And so the plaintiff cannot claim that the way it was damaged was through this contract and then try to argue that this isn't at heart a contract case. Interpretation of the contract, the parties' performances and responsibilities under the contract, and whether the contract was priced at fair market value are central and inseparable issues to the plaintiff's theory of this case, and therefore the contract itself can't be extricated from the tort claims. So therefore, we argue the case arises out of the contract, and therefore its forum selection clause should be enforced. The business court seemed to focus on the fact that this forum selection clause was unusual in the way that it was drafted, but it made no findings as to why it should therefore be unenforceable. Excuse me. And the court seemed to focus heavily on the logistical problems that the plaintiff might face because some of the defendants may not be subject to jurisdiction in California. For example, it said, well, Winter may not be subject to jurisdiction in California, even though, as we've just discussed, he likely would have because of those stock options in Symphony. However, again, the court applied a disparate analysis because it didn't seem to mind that when it dismissed the Baker-Botts defendants for lack of personal jurisdiction, that plaintiff may have to pursue them in another forum. And indeed, plaintiff has filed suit against those defendants in Texas and is pursuing parallel litigation right now in two jurisdictions. So an alleged inconvenience to a party is not a reason to void a valid, albeit unusual, forum selection clause in the contract. And indeed, parties are frequently forced into arguably inconvenient jurisdictions or arbitrations based on the agreements that they sign as sophisticated parties who've negotiated a contract. And so while we believe that there are not sufficient minimum contacts for the court to exercise personal jurisdiction over the Symphony defendants for the reasons I've just described, if the court is not convinced by those arguments, we would argue that the case certainly should have been dismissed and transferred to California because of the application of the forum selection clause in the contract. And unless the justices have any questions, I would like to reserve my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court, Mr. Chief Justice, members of the court. My name is Stacy Miller, and I'm here on behalf of the appellee, Diamond Candles. The appellee respectfully asked this court to rule that Judge Gale did not abuse his discretion because the appellant's contacts with the state of North Carolina are sufficient to support a finding of personal jurisdiction. B, the forum selection clause does not apply to appellee's claims because they do not arise out of the service contract between Diamond Candles and Symphony Commerce. And 3, the balance of inequities does not warrant a stay of the proceedings under the forum nonconvenience clause. With respect to the appellant's 12B2 argument, we believe the court did rationally make a decision when it ruled that the exercise of personal jurisdiction was well-founded in North Carolina's long-arm statute and was also consistent with due process. First, Diamond Candles claimed that Symphony Candles substantially overcharged them in a service contract, comports and falls within the broad scope of a local injury as contemplated by the long-arm statute. Now, relative to the due process claim, which I believe is at the heart of the appellant's argument, we believe that the court found correctly that the plaintiff sufficiently invoked specific jurisdiction because the plaintiff has shown that the plaintiff's claims arise out of or relates to the defendant's contacts with the state of North Carolina. And by engaging in those contacts, the defendants have availed themselves to the benefit and the protections of the laws of their state. Now, in paragraph 61 of the court's order, the court found numerous things which it relied on in support of its reasoned decision. And what the court pointed out first, which distinguishes this case from all the cases that the appellants argue in their brief, is that on November 14th, defendant Winter traveled to North Carolina for the purposes of creating and initiating what they call Plan B, which was to acquire defendant Candles' company at a subverted price and flip it at multiples of the acquisition price. But they didn't stop there. According to, it can be found in Mr. Kim's affidavit on, let's see here, page 43 of the record. He came to North Carolina a total of 8 times in connection with his business with Diamond Candles. I submit to this court that that's actual contact with the state of North Carolina, wherein he enjoyed the benefits and protections of this state while he was here. The court also cited that from 2012 to 2018, Symphony Commerce enjoyed a revenue stream in the amount of $22 million. In addition to that, the court found that the contact of Symphony Commerce provided stock options to defendant Winter, a North Carolina resident, to promote the implementation of Plan B. And the record is also replete with numerous emails and phone calls wherein Kim advised Winter on the complexities and the varieties of executing Plan B. So the court found that the pathway to personal jurisdiction over Symphony Commerce is clear. The defendants have relied on a case, Market v. America, or Market America v. Opti Health, which they submit holds that defendant Kim is not subject to jurisdiction because in his 8 travels to North Carolina, he did so during the scope and course of his employment with Symphony Commerce. But I submit to you that argument is very specious in as much as they have carved out and spliced out the seminal part of the holding in that matter. And I read, and as the trial court found, general actions by a person on behalf of a corporation were generally not subject a person to out-of-court jurisdiction, but actions related to events in question may do so. Here, Kim clearly was traveling to North Carolina to conduct the actions and events to which the plaintiffs have complained about in their complaint. Furthermore, he's standing to personally gain from Plan B. So I submitted to this court, he was traveling to North Carolina on 8 occasions, personally and as an agent on behalf of Symphony Commerce. So in conclusion of the personal jurisdiction argument, we conclude that, or submit to this court, that Symphony Commerce and Kim's contacts in North Carolina were frequent and numerous. They were significant in substance. They were connected to the cause of the action in the plaintiff's complaint. And North Carolina has a profound interest in protecting our corporate citizens. Again, all of the cases that the appellate cite, and also distinguishable from Baker Botts, is that Baker Botts never traveled into the state of North Carolina. Whereas here, Mr. Kim traveled 8 times on behalf of himself and on behalf of Symphony Commerce. Now, if it pleases the court, I'd like to address the appellate's 12B3 argument regarding the forum selection clause. Again, we submit to this court that the trial court did not abuse its discretion because it found that the appellee's claims do not arise out of the e-commerce or the services agreement with Diamond Candles and Symphony Commerce, because the court found the nature of the plaintiff's claims are sounded in tort and are extra contractual remedies and do not arise out of the contractual relationship between the parties. Just because the plaintiff uses evidence of the amount of payment of a contract in their claim does not mean that the claims arise out of the contract. The jury will never have to interpret the terms of the contract, will never have to interpret whether the obligation was fulfilled. In fact, the appellants argue in their brief that the plaintiff's claims are contingent on proving that the contract was false or fraudulent. I'll submit to this court that the plaintiffs do not have to do so at all. In fact, we may offer that the contract was valid. Defendant Winter was CEO, had capacity to contract, and did in fact contract with Symphony Commerce for e-commerce services. albeit the price was over fair market value, but that does not mean that the contract price was unconscionable. Perhaps it was a bad decision on Diamond Candles' part, but the price of the contract itself does not specifically by itself give rise to the plaintiff's tortious claims in this matter. And I would submit to this court, if the appellants really thought this case was a contract case in disguise, we would be arguing a ruling on a 12B6 matter instead of a forum selection clause. Finally, appellants have argued that this matter should be stayed under the doctrine of non-convenience. The trial court reasons, and I believe properly so, that the appellants have failed to overcome the strong presumption that action should not be disturbed when a plaintiff files in its home state. And it simply cannot be said that the court abused its discretion in denying the defendant's motion for non-convenience when there are more witnesses in North Carolina than any other jurisdiction. The appellate has argued that there might be numerous witnesses that live in California, but they have not shown their names or identified whether it would be necessary to subject those witnesses to the compulsory process, which they are required to do under the doctrine of forum nonconvenience. Defendant Winder is a resident in North Carolina and is not subject to personal jurisdiction in California. And North Carolina has a significant interest and concern over this case because it affects a corporate resident and an employment matter between two North Carolina residents. Finally, California is not a convenient state for 3 of the 4 principles in this case. So I'd like to conclude this argument by again asking the court to affirm the trial court's decision and find that there were minimum contacts sufficient to establish personal jurisdiction in this matter, and that the defendants did avail themselves to the benefits and the privileges of the state, and finding personal jurisdiction, in fact, does not subvert fairness or substantial justice. 2, that the plaintiff's claims do not arise out of the service contract between Diamond Candles and Symphony Commerce, thereby resulting in the inapplicability of the forum selection clause. And finally, the equities of justice does not warrant a stay in this matter. Thank you.
Thank you, counsel. Rebuttal.
Just briefly to address some of the points made by Mr. Miller. Again, I would point the court to the inconsistencies between the treatment of the parties, just to address the forum nonconvenience argument. So the business court was not concerned about the plaintiff possibly having to litigate in Texas when it came to BakerBots. BakerBots also had witnesses located in other states, while most of the witnesses were in North Carolina. BakerBots had an ongoing legal relationship with a North Carolina company for several years. It was paid for that relationship. The complaint is specific that Lee and BakerBots were involved in negotiating and planning the Plan B, quote unquote, takeover of the company, and yet BakerBots was dismissed. Mr. Kim traveling to North Carolina appears to be the only valid distinction between the two defendants, and the court itself noted in the underlying order granting the BakerBots motion and denying the Symphony defendant's motion that a physical presence in the state doesn't really matter. It's the frequency with which these parties were dealing with each other and the frequency with which the defendant avails itself of the forum state. And I would argue that the constant communication between Lee and Winter was similarly frequent. Just because Lee didn't get on a plane doesn't mean he wasn't actively involved in this Plan B process. And so if one rule applies to the Baker Botts defendants, the same rule should apply to the Symphony defendants. With regard to Mr. Miller's arguments that the case doesn't arise out of the contract, if the sole way that the company was drained of its value, which is the primary argument for damages and the primary argument for damages by the plaintiff here, if the sole way that the company was drained of its value was through that e-services contract, it's just inconsistent that this isn't a contract case. No, the claim is not a breach of contract, and the plaintiff may not be claiming that anyone breached the contract, and we agree with that. But if the contract was in fact priced at fair market value, then there's simply is no improper devaluation of the company, and therefore no conspiracy or improper behavior by these defendants at all. It simply means that, as Mr. Miller pointed out, Diamond Candles made a bad business decision and signed a bad contract and lost more money on it than they thought they were going to. It doesn't mean that these defendants committed any torts. And so, again, I'm not trying to say that this is a breach of contract case. What we are arguing is that the terms of the contract and performance under the contract are central facts to plaintiffs' tort claims here, because even they concede that the means by which defendants carried out this alleged conspiracy to devalue the company was by overcharging them for services under the contract. And I just don't see how those issues can be divorced. And with that, I think, may it please the court, I don't have anything else to offer unless any of the justices have further questions that I could answer.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court.